Good morning, this is your Kelso Report for Monday, December 3rd. I'm your host, Clark Kelso. We begin with a case involving waiver of a defendant's right to appeal in a criminal proceeding, and then turn to the state's obligation to pay for production of the administrative record when the petitioner is indigent. We have a decision affirming the permitting of a desalination plant, and finally we have the scope of Proposition 36's provisions that prevent an arrest or conviction from being used in subsequent proceedings. First, the Ninth Circuit. One of the issues that is usually negotiated in a plea agreement is the defendant's total or partial waiver of his right to appeal. In United States v. Arias Espinoza, the Ninth Circuit faced a case where there was a complete waiver of the right to appeal in the written plea agreement. At the change of plea hearing before a magistrate judge, the defendant said that his counsel had explained the plea agreement and that he understood it. And he said he understood he was waiving his right to appeal. The magistrate judge, in his findings and recommendations, told the district court that the defendant had knowingly, intelligently, and voluntarily waived his right to appeal as stipulated in the plea agreement. At the sentencing hearing, the district court adopted the magistrate judge's findings and accepted the guilty plea. The court sentenced the defendant to 51 months within the range specified in the plea agreement. But here's where things went a little bit awry. At the end of the hearing, the court advised the defendant that, quote, "you may have a right to appeal the sentence," close quote. Well, the question on appeal, of course, was whether this statement by the district court vitiated the defendant's written waiver of his right to appeal. The Ninth Circuit has previously held that a clear, unequivocal statement by a trial judge that the defendant has a right to appeal sentencing findings does render a prior written waiver unenforceable. But in this case, the Ninth Circuit held the oral statement was ambiguous, particularly because of the use of the word may, and so the district judge's statement did not vitiate the waiver. Obviously, the better practice for the trial judge is just to reiterate that the right to appeal has been waived, so that the defendant will not be confused by the trial judge's ambiguous, ambivalent statement. Next, we turn to an administrative law case. Our commitment to the right to appeal is constitutionally grounded, and the same goes for the right to receive judicial review of administrative agency actions. Part of that constitutional right includes the right of an indigent litigant to have certain costs paid for by the government. In Austin v. Valverde, the Second District faced an indigent petitioner who had filed for a writ of mandate to challenge the DMV's decision to suspend his driver's license for refusing to submit to a chemical test of his blood alcohol. To support his petition, he wanted to refer to the record of the DMV hearing, which had been audio recorded. The applicable statutes require DMV to bear the costs of preparing the record when the petitioner is indigent. DMV prepared the record, but then refused to turn it over to the petitioner free of charge, arguing that the statute applied only to the costs of preparing the record and said nothing about whether DMV could charge for a copy of the record. Well, the Second District rejected this technical argument, holding that the legislature plainly intended for the agency to prepare and deliver a copy of the record free of charge to an indigent petitioner. I mean, I know the state's budget is bad, but going after an indigent for the cost of a copy, goodness, the lawyers got a little carried away there. Next, environmental law. The regulatory tools of environmental law are tailored to the environmental risks presented. For some risks, all that is required is that the environmental impacts be studied and identified. For more serious risks, substantial mitigation may be required. And for even more serious risks, there may be a requirement that the best available technology be used in a project. That high standard was before the Second District in its review of a decision to approve the permits to construct a desalination plant along the coast in Carlsbad, California. The challenger to the permit, Surfrider Foundation, argued that the San Diego Regional Water Quality Control Board unlawfully failed to require the best available site design and technology measures, and instead relied solely upon mere mitigation measures to reduce environmental risks. The applicable statute clearly required best available site design and technology, so if the challenger's factual allegations were true, the permit would have been issued unlawfully. However, the 4th District in Surfrider Foundation versus California Regional Water Quality Control Board found that the challenger's allegations were unsubstantiated. The board did in fact require best available site design and technology, as well as require best available mitigation measures. So the court affirmed the issuance of the permit. Next, criminal sentencing question. Although California is generally a tough-on-crime state, the people have clearly turned against serious enforcement of drug laws when it comes to personal use. In People v. Ziegler, a panel of the 6th District seems to have missed that trend, issuing a decision that I suspect will be reviewed by our Supreme Court. The defendant petitioned for a certificate of rehabilitation regarding 2 prior drug convictions in 1989 and 2000. The people opposed the petition on the basis that it was barred by defendant's new nonviolent drug offense in 2007, for which he had been granted probation under Proposition 36. The defendant argued that because his 2007 conviction was actually set aside and the charges dismissed after he successfully completed a Prop 36 drug treatment program, the offense could not be considered in evaluating his petition for a certificate of rehabilitation. Indeed, the law expressly provides that records, quote, pertaining to an arrest or conviction resulting in successful completion of a drug treatment program under Prop 36 may not be used in any way that could result in the denial of any certificate, close quote. Penal Code Section 1210.1. Well, notwithstanding this directive, the panel agreed with the prosecution's argument that it should have been allowed to put on evidence regarding the underlying conduct that led to the Prop 36 case, even though it couldn't use the prior records of the case. The Prop 36 language barred use only of the records of arrest or conviction, saying nothing about the underlying conduct or facts. Technically, perhaps correct, but it seems to me the court here has given the statute a reading almost certainly at variance with what the people would have reasonably intended, and it creates a gaping hole in the statute that undermined what appears to be its central purpose. So I'm predicting the Supreme Court will grant review in this case. That's it for today's Kelso Report. Have a great day in the law.